This podcast is brought to you by Progressive Insurance. What if comparing car insurance rates was as easy as putting on your favorite podcast? With Progressive, it is. Just visit the Progressive website to quote with all the coverages you want. You'll see Progressive's direct rate, and then their tool will provide options from other companies, so you can compare. All you need to do is choose the rate and coverage you like. Quote today at Progressive.com to join the over 29 million drivers who trust Progressive. Progressive Casualty Insurance Company and Affiliates. Comparison rates not available in all states or situations. Prices vary based on how you buy. Hey, What Next listener. Before we start the show, I want to let you know about a story coming up a little bit later. It's from one of our partners, SAP. AI comes at you fast. If you don't get reliable and relevant advice, your business might miss out. Whether you're looking to automate tasks or embed AI in your business processes, SAP can help. To learn more, head to sap.com/AI and stick around for expert advice on how to embrace AI with confidence.
Okay, so Steve, it is ingrained in us as Americans that our government runs on a system of checks and balances. We're taught this starting in elementary school. Have there been many checks on the judicial branch in the last few years?
No.
Steve Vladeck is a professor at the Georgetown University Law Center.
I think we've seen very much in real time how few checks there are on the courts today. We've seen reports of justices' behavior that certainly ought to be or ought to have been checked. We've seen the Supreme Court handing down decisions that are hard to imagine in a world in which it was meaningfully being checked. And so I think, you can look all over and find examples of federal courts today acting as if they're just not looking over their shoulder at anyone or for any reason.
Steve is an expert on constitutional law and the federal courts. We called him up because last week, as part of a Hail Mary pass to stay on the Democratic ticket, President Biden told lawmakers he was planning a major initiative to reform the Supreme Court.
I think this is a conversation that is long overdue, and it's one that the president has had multiple previous opportunities to help try to stimulate. And coming when it's coming and focusing on what at least the reporting suggests it's going to focus on, it really strikes me as well more than a day late and well more than $1 short.
I liked how you put it. You referenced Casablanca, the movie, that it's like, I'm shocked that gambling is going on in here.
Yeah, I think, this is something that folks who follow the court carefully have been really beating the drum about for 5, 6, 7 years.
This past weekend, Biden dropped out of the race, and now all eyes are on his VP. But here's the thing. Biden still has about 180 days left in office, half a year. That's a lot of time to get things done, and he went out of his way to shout out court reform in his address to the nation last night.
I'm going to call for Supreme Court reform because this is critical to our democracy, Supreme Court reform.
The polling on the Supreme Court, the polling on things like, sort of modest accountability reforms, modest oversight reforms, is so generally positive that if the conversation were framed in the sort of space of how do we make the court more responsive, how do we make the court more in dialogue with the other branches, as opposed to how do Democrats attack the Republican court, maybe you don't get legislation tomorrow, but at least we start moving towards some kind of conversation that frames the debate not in terms of Democrats versus Republicans, but in terms of institutions versus institutions.
So even if Biden's Hail Mary pass didn't pay off for him, maybe it opened the window for real reform. It's true, you need congressional approval to change the court, but Congress has regulated the court before.
The idea that any time Congress lifts a finger toward the Supreme Court, it's interfering with judicial independence. And the notion that judicial independence is this sacrosanct thing that requires that the court be left alone. The problem is that it's not just that that's wrong as a matter of text and history, is that it has everything backwards. The reason why we trust the court to be independent, the real source of the court's power, is our perception that the court is accountable.
Today on the show, could the court really change before the next election? I'm Yasmin Khan, in for Mary Harris. You're listening to What Next? Stick around.
This podcast is brought to you by Slate Studios and SAP. AI is moving so fast. If you don't get reliable and relevant advice, your business might miss out. Welcome to Dear Artie, an advice column from SAP, where we tackle the tricky questions at the intersection of AI and business. Here's our expert, the technology futurist, Ian Kahn.
Hi, I'm excited to dive into today's question.
Dear Artie, the supply chain has been a friend and foe to my company. Can AI make us more resilient? Signed, Supply Chained to Uncertainty.
Hey Supply, here's how AI in the supply chain can help. AI can massively automate data analytics and understand the movement of your goods. AI can point out weak links, market demand trends, optimal logistics, and other important aspects that impact the top and bottom lines for the business. Take the example of a large grocery chain that has hundreds of vendors spread through the country. In some cases, you may need to reroute shipments to other stores, such as in the case of fresh produce, a good that can go bad very fast. Managing such a supply chain is heavily dependent on the data provided, and AI can help optimize this information so that your supply chain works at its optimal levels.
Embrace AI with confidence. Head to sap.com/AI to learn more.
This episode is brought to you by SAP. First, the bad news. SAP Business AI will not help you generate cubist versions of your family's holiday photos, but it will help you understand which supplier is best to help you roll out your plant-based packaging in Southeast Asia, or identify the training your junior project manager needs to rise up the ranks, or automate repetitive tasks while you focus on big innovations. So you can be ready for the next opportunity. Revolutionary technology, real-world results. That's SAP Business AI.
On Wednesday night, Biden promised publicly to call for court reform. But what we know about the specifics of his plan comes from reporting.
Assuming the reporting is accurate, and we should always take a little bit of a grain of salt with that, although the White House hasn't denied any of the reporting from the Washington Post and other outlets. There are three apparent primary features to this plan. The first is to impose term limits on the justices so that each justice can only sit on the big cases for 18 years. The idea being that every 2 years there'd be a predictable vacancy for the incumbent president to fill. The second part of the proposal is to create some kind of enforceable code of conduct that carries a whole lot of baggage with it, but the idea being sort of a response to the perceived misbehaviors of especially Justices Clarence Thomas and Samuel Alito. And the third part is more directly responsive to the Supreme Court's decision on July 1st in the presidential immunity case, where the president apparently wants to propose a constitutional amendment that would overturn that decision and hold that, in fact, no, presidents are not immune from criminal prosecution for even official acts they take while in office. So that seems to be the three parts of the proposal.
Let's talk about how these reforms might actually work. What are Congress's powers over the court? What's written into the Constitution about that?
Sure. So the two express powers that Congress has, the first is the power to control the Supreme Court's appellate jurisdiction. And that may sound really small and nerdy, but that's actually really, really important, both because that is almost all of the court's docket. It's 99+% of the cases the Supreme Court hears. And because there's a ton of powers that are incidental to that power with regard to how the court does its job. And then Congress also has the power under something called the Necessary and Proper Clause in Article 1 to make all other laws that are necessary and proper for carrying into effect the powers over the court's jurisdiction over its functions that Article 3 gives Congress expressly. So using those powers, Congress has historically regulated the size of the court, where the court sits, when the court sits, the court's budget, the justices' travel, the justices' docket, and all other sort of things short of that. The court's library exists only because of Congress. The justices have law clerks only because of Congress. The justices' decisions are published by the federal government only because of Congress. In all of those ways, the court always has been, and really is even still today, dependent upon the political branches, whether the political branches recognize it or not.
Okay. So Congress, you're saying Congress does have the authority, certain authority to curb the court. So what would the actual process look like for passing any reforms that Biden proposes?
I mean, it's all just statutes at this point. So, there are already a bunch of bills that have been introduced, especially in the Senate, to, pursue either variations on what it sounds like President Biden's going to propose or other reforms. If you could somehow get those bills through Congress, which of course means a filibuster-proof majority in the Senate and a Republican-controlled House, they'd go to the president's desk for signature. I think part of the problem is that no one thinks that's realistic right now.
This is where I get stuck, because you're telling me that Congress does have the authority to regulate the court in some ways, but there's been a fair amount of chatter in recent years implying that Congress doesn't have the power to do that. And Justice Samuel Alito has essentially said as much. In a Wall Street Journal interview last year, he said, quote, "No provision in the Constitution gives Congress the authority to regulate the Supreme Court, period." So where is this all coming from?
So, I mean, first we should say, Alito is wrong in almost hilariously obvious ways. I mean, there's a provision in Article 3 of the Constitution that literally gives Congress the power to, quote, make regulations, unquote, of the Supreme Court's docket. But Yasmin, I think where this is coming from is two different but overlapping ideas. So the first is, for the better part of a generation, Congress hasn't pulled any of these levers, as opposed to the first 150, 175 years of our history, where Congress was routinely doing lots of stuff big and small to leverage the court, to nudge the justices. Really, over the last 35 years, Congress has totally stopped. Just one obvious example of this, the court's docket, right? So, the Supreme Court this year decided 59 cases. That's the fifth term in a row that the court didn't get to 60. These are all cases the justices are picking. Congress has gradually given the court more and more control over its docket, even though historically Congress controlled the court's docket. And as the courts had more and more control, it's done less and less. So, phenomenon number one is Congress has stopped doing all the stuff it used to do. And then, I think we now have a generation of judges and justices who have grown up in the era of Congress not doing anything. And so to whom it would feel strange, if not alien, for Congress to all of a sudden start doing some of the things it used to do. So when Alito says what he said to the Wall Street Journal last summer, he's wrong as a matter of text. He's wrong as a matter of history. He's wrong as a matter of common sense. But he's still, I think, capturing something that's out there in the zeitgeist, which is, the idea that, Congress shouldn't be touching the court. It's just, it's not something it does. And it would be bad if it did, because we just have, put blinders on about how things ran from really 1789 until the 1980s.
Can you just give another example or two of how Congress has provided oversight over the court?
Sure. I mean, so one of my favorites is the Supreme Court did not sit at all in the year 1802. We talk a lot about sort of the original understanding and what the founders understood about power. Well, after the election of 1800, when Thomas Jefferson and the Democratic Republicans were swept into power and the Federalists were swept out of power, the only place where the Federalists still had any sway was the Supreme Court. And so Congress just said, hey, Supreme Court, you know what? You're not even going to sit this year. Not sort of as a way of saying, hey, we don't want you to ever sit again. But Yasmin, as basically pointing a gun at the court's head and saying, hey, you can't sit unless we let you. And so maybe you should chill. Slightly smaller than that, but also I think another illustrative example. There's a great statute Congress passes in January of 1882, where it basically says, hey, Justice Ward Hunt, there's someone no one's probably ever heard of, we want you to retire. And so here's the deal. If you retire from the Supreme Court within 30 days, we'll give you a pension. lo and behold, Justice Hunt retired, creating a vacancy for, I think it was President Arthur to fill. So, history is rife with examples like this of statutes big and small, where Congress exerted leverage over the justices as a way of keeping the court relatively in line with, the general sort of popular opinion.
It sounds like the question is not just about, does Congress have the authority to regulate the Supreme Court? It's that Congress has a responsibility to regulate the court or provide some oversight. Why has it backed away from that role?
That's the harder question. I think it's a two-stage story, and the first stage is harder to explain than the second. So if we work backwards, the second part of the story will be familiar to folks. The second part of the story is polarization. That, as Congress has become increasingly polarized, reflecting the increasing polarization of our politics, Congress has stopped being interested in what we might call institutional legislation, where you don't have liberal Republicans and conservative Democrats coming together to stand up for Congress as an institution, where it's all about the separation of parties, not the separation of powers. So I think that's why over the last, 25, 30 years, we've seen no way out of this logjam. Before that, I think the best explanation for why Congress just started taking its hands off is that, for better or for worse, we had a couple of generations of a Supreme Court that was not always right, but that was generally perceived as staying in its lane, as acting in a way that was institutionally appropriate and responsible. And you had a court from, the late 1960s, the very end of the Warren Court, into really the early 2010s, that had a very well-tended middle. You had people like, Justice Lewis Powell and Justice Potter Stewart and Justice Sandra Day O'Connor and even, John Marshall Harlan II and Anthony Kennedy, where, the court was basically sort of self-policing because of this sizable block in the middle. And so Congress, I think, didn't think it was a problem. And it's only in the last, 6 or 7 years, when the court's middle has completely disappeared, that all of a sudden we see, hey, look, the court is actually totally unaccountable. And now we have a Congress that, for, broader political reasons, is not in a place to push back.
Coming up, what will it really take to get the court back on track?
This show is brought to you by Discover. Have you heard about Doublenomics? It's okay if you haven't. It's extremely niche and practiced by Discover. Here's an example. Discover automatically doubles the cash back earned on your credit card at the end of your first year with Cashback Match. That means with Discover, you could turn $150 cash back into $300. It pays to Discover. See terms at discover.com/creditcard.
I'm David Remnick, host of the New Yorker Radio Hour. There's nothing like finding a story you can really sink into that lets you tune out the noise and focus on what matters. In print or here on the podcast, the New Yorker brings you thoughtfulness and depth and even humor that you can't find anywhere else. So please join me every week for the New Yorker Radio Hour, wherever you listen to podcasts.
We've talked about whether Biden can reform the court, assuming Congress cooperates, which of course is a big if. But whether he should reform the court is a separate question. So I'm curious, do you believe that court reform is a good idea?
Unequivocally. We've been talking a lot about the separation of powers. And, one of the reasons why our Constitution exists and is styled the way it is because the founders desperately believed that we had to have an independent judiciary as a check against tyrannies of the majority. And they were right. The problem is that they believed just as deeply that you had to have political accountability through the democratically elected branches so that we also didn't have a tyranny of unelected judges. And, Yasmin, the problem is that is a messy balance that requires ongoing push and pull from everybody. And the more that Congress just sort of takes its hands off the court, the more you end up with what we have today, which is a Supreme Court that is taking only the cases it wants to take, that is deciding only the issues it wants to decide, that is routinely defying statutory limits on its power, that is in some cases defying constitutional limits on its power, and that is handing down decisions that I think are, whether you like them or not, having just radical effects on not just all of our everyday lives, but on the structure of our government.
Would Biden's proposals address any of those problems?
No. So Congress gets to define what it means to be a Supreme Court justice. But for Congress to apply that definition to current office holders would raise serious constitutional problems. So to do term limits by statute, which is what I gather the Biden administration is going to propose, it would have to be prospective only, meaning starting with the next vacancy. And ditto for ethics. For ethics, yes, I think Congress has the power to pass rules that the justices are bound to comply with. It already has. There's a series of provisions in a statute called the Ethics in Government Act of 1978 that apply to the justices. There are, recusal and disqualification standards in part of the U.S. Code that apply to the justices. Yasmin, the issue is who's going to enforce it. And once you have someone enforcing that who isn't the court and who isn't appointed by the court, you run into serious constitutional problems. So with both of those proposals, for them to be effective in the short term, you'd have huge constitutional objections versus ways of making them constitutional, but also ineffective, certainly at least for now. And then last, just as for a constitutional amendment to sort of overrule the Trump immunity ruling, it sounds like a great idea, leaving aside that it will never happen. If we're going the constitutional amendment route, I can think of some other recent Supreme Court decisions that we might want to talk about overruling, whether it's Dobbs and its overruling of Roe versus Wade, whether it's Bruen and its reading of the Second Amendment, whether it's the court's 2010 decision in Citizens United, which opened the spigot to tons of dark money flowing into our political system. It's just like, it seems very half-cooked.
In your mind, what would be better changes to the court?
I would start with three very different sets of reforms. The first would be docket reform. I would have Congress reclaim at least some control over which cases the justices are hearing, not as a way of punishing the court, but as a way of actually requiring the court to do more and to hear cases the justices don't want to hear, the kinds of cases historically where they actually had to be judges and not just, politicians in robes. So docket reform would be point number one. Point number two is an inspector general. We are long overdue for some kind of ombudsperson within the judicial branch, just like we have in, the executive branch and all of these agencies, to actually monitor the extent to which judges and their employees are complying with the relevant federal laws and federal rules and federal disclosure requirements. I think constitutionally, the inspector general couldn't have the power to punish the justices if they misbehaved, but he or she could sure file public reports documenting those abuses that would, I think, help to disincentivize them in the first place. And then third, and just more generally, Congress used to have hearings all the time where they would actually talk about what the court was doing with all of the money Congress was giving it. There's a famous hearing in 2001 where Justice Anthony Kennedy had to actually defend the court's decision in Bush versus Gore as part of the court's budget appropriations process. That's healthy. Yes, other branches, should have to explain themselves to each other. And I think Congress has just given up the ghost on that, so much so that, Chief Justice Roberts, when he was asked to testify last year, after all of these, alarming reports came out, said, we don't do that sort of thing. And historically, actually, they did. So, more of the sort of classic oversight that Congress conducts over the executive branch should be directed toward the court, an inspector general to help with that, docket reform to actually have the court do more stuff that it used to do, all of which has at its sort of core the same idea, which is overseeing the court is actually central to Congress's job.
The institutionalist argument against court reform is, maybe just to put it simply, that messing with the court is a slippery slope. That first Biden does it, then his successor, until the court becomes just this political instrument, more so. Does that argument carry any water?
Yes, I think it's a concern. And that's why I think the which reforms really matter. So one of the reasons, for example, why I think expansion is a really bad idea is, Yasmin, exactly the race to the bottom that it would instigate, where, let's say there was a political universe in which Democrats actually could add 4 seats to the court in 2027 or 2025. Well, the next time the Republicans have a trifecta, they'll add 8 seats, and then the Democrats will add 12. And all of a sudden, the Supreme Court will have 51 justices and 0 credibility. So yes, that is a concern. It's not, I think, a complete and reform defeating concern if you frame the conversation the right way. If you say, well, look, we're not talking about doing anything new. We're talking about bringing back the way we've always done it. I mean, Mitch McConnell had a statement a couple of weeks ago where he said, Congress has no business telling the Supreme Court which cases to hear. And Yasmin, my response to that is, well, where were you for the first 200 years where Congress regularly told the court what cases to hear? No one ever argued that that was unconstitutional. So once again, the more this is about, sort of restoring prior practices that was better for the relationship between the court and the rest of the country, I think the less the slippery slope water holds argument. And if the worst that can be said about Supreme Court reforms is that it's making the court more responsive to, the democratic majorities of the moment, that to me strikes me as far more a feature than a bug.
Steve, I really appreciate this conversation. Thank you so much for your time.
Thanks. That was fun.
Stephen Vladeck is a professor at the Georgetown University Law Center and an expert on the federal courts and constitutional law. That's the show. If you're a fan of What Next, the best way to support our work is to join Slate Plus. Go to slate.com/whatnextplus to sign up. What Next is produced by Paige Osburn, Elena Schwartz, Rob Gunther, Anna Phillips, and Madeline Ducharme. We're led by Alicia Montgomery with a little help from Susan Matthews. Ben Richmond is the Senior Director of Podcast Operations here at Slate. And I'm Yasmin Khan. Thanks for listening. Talk to you soon.
Okay, you say, I want some breakfast. Your so-called boyfriend says, we got eggs in the fridge. Obviously, when you say breakfast, you mean McDonald's. Definitely a side-eye situation.
Bring home the bacon, steak patty, or others with a BOGO for $1 breakfast. Only in the app. Limited time only at participating McDonald's. Valid once a day. Must opt into rewards. Visit McD app for details.
Ba-da-ba-ba-ba.